All right, I think we are going to get started. Good afternoon, everyone. Thank you for joining us. We're excited to welcome our very own ERISA attorney and benefits expert, Dan Cooperstein. He's a senior vice president of compliance here at Corporate Synergies. Dan is going to walk us through some important updates on compliance requirements under the CAA of 2021, coverage rules, fiduciary responsibilities, new disclosure mandates, and what the second Trump administration means for all of this. So if you have a question, please feel free to submit it in the chat. And if we don't get to your question today, one of our experts will follow up with you and address your question. Also, if you're here for SHRM or HRCI credits, they will be awarded via email for those who are eligible. And today's recording will also be available within the next day or two. So with that, Dan, feel free to take it away.
Great. Thanks, Brianna, and welcome everyone. So today we'll be diving into the always exciting and ever-changing world of healthcare transparency regulation. And as an ERISA attorney, I'm going to do my best to make this informative and helpful for benefits and HR teams, and with as much plain English as I possibly can, because I know this stuff can have a lot of legalese. And also, like as Brianna mentioned, we have a lot of content today, so I'm going to be going through it pretty quickly, but if I don't get to your question, just put it in the chat and we will get back to you. So let's go ahead and get started. Um, so today, on today's agenda, we're going to actually start off with a discussion of a very big recent development that happened, the One Big Beautiful Bill Act. Even though it's not a transparency development, it's so important and so big. I think it's just important that we kind of talk about that. And then we're going to dive into providing an overview, really kind of giving a big picture view of transparency regulation for health and welfare plans, um, and really just try to get a good understanding of the policy goals, sort of the big picture view first, and some of the policy goals, the why behind the transparency regulations. And then the what, right? What are those regulations, those laws and regulations? We'll be really focusing on the transparency and coverage regulation, including the MRF disclosures, the Consolidated Appropriations Act of 2021 or CAA of 2021, including the No Surprises Act and ERISA disclosure rules. And then we're going to talk about some of the more recent noteworthy developments in transparency regulation. We'll talk about the MAPIA, the Mental Health Parity Law change that happened recently, how, under the CAA. And then we'll talk about the Trump effect on transparency, as well as how ERISA, so some of the recent ERISA health plan fee litigation that's coming around right now. So a lot of stuff, and we'll kind of close out talking about some common pitfalls to avoid and liabilities to avoid, and then close off talking about some best practices and key takeaways. So a lot on the agenda, and I'm going to be going pretty quick, but don't feel free to put your questions in the chat, and we'll go through it. Okay, so let's start with the One Big Beautiful Bill Act. This was a major something that was contemplated for a long time, really a major legislative victory for the Republican Party. It was signed into law by President Trump on the 4th of July, and it really does a number of things for employee benefits that are just important to be aware of. And I'm not going to go into too much of the detail here. This is really just sort of a kind of a quick overview of the major changes. But one of the big things that it really did was it really improved HSAs, right? So it really made health savings accounts much better by permanently extending the safe harbor for pre-deductible reimbursement of telehealth under high deductible healthcare HSA coverage. This was part of a safe harbor that was first made available under the CARES Act during the COVID pandemic. And this is actually going to go back retroactively back to January 1st of 2025. And then for plan years beginning on or after January 1 of 2026, it's going to be treating all bronze and catastrophic plans that are available in the ACA exchanges as qualified high deductible health plans and thus as HSA compatible. So it's going to make HSAs even more flexible than they were before. And then for plan years beginning on or after, also for all on or after 1/1 of 2026, the law changes the existing law to exclude direct primary care arrangements from being a form of HSA disqualifying coverage. So in other words, now direct primary care coverage will be HSA compatible, which is a huge change, huge boon for the the direct primary care industry, and makes HSAs even more flexible. There are some limitations on that, but that's going to be really helpful for HSAs. It also, one of the big things that it does is it increases the maximum contribution for dependent care FSAs from 5,000 to 7,500, which, while that's not indexed for inflation, it's very much welcomed by employers and plan participants. That's been at that rate since 1986. So it's for 40 years, it's been at $5,000 with no change. That's a huge improvement for the DCAPs. It also makes permanent the ability for employers to offer tax-free student loan repayment assistance under Code Section 125 Qualified Educational Assistance Program, and then begins indexing that max limit that you can contribute starting in 2026. And then it permanently eliminates the new law permanently eliminates the qualified bicycle commuting reimbursement exclusion, which was something that had been done on a temporary basis as part of the tax reform law, the TICJA, but now it will be permanently eliminated. But it also gives an additional year of inflation adjustment for all those other qualified transportation fringe benefits, which is a nice plus for participants and increases the reimbursement on those. And then it makes permanent or extends several of those provisions of the TICJA, which is really kind of the main, thing that was kind of motivating this thing, right? It's going to continue to keep those lower taxes locked in for individuals and those better deductions for businesses. So that was a kind of a big piece of this. And some other benefits related items. It permanently increases the child care tax credit. The maximum credit goes from 150,000 to 500,000, and it enhances 529 accounts. It creates new Trump accounts, which are really kind of set up kind of like a combination of an IRA and a 529 account, that will be set up for children. They'll get some money from the government as sort of like seed funding, and then the children will be able to take that out for certain reasons at age 18. And then it enhances the paid family leave tax credits, and then makes changes to the ACA exchange rules, several reforms to those rules in the Medicaid program, among other changes that really affect more individual coverage. And while there could be some increases expected in the cost of premiums for individual health insurance plans as a result of those things, it's really kind of unclear still how that's going to affect the employer market, but we're watching it very closely. So that's kind of the big picture on the new One Big Beautiful Bill Act, and there will be more to come soon on that. We will be doing a presentation in September on that, in which we'll talk about that in much more detail. So stay tuned on that. Okay, so let's dive right into the meat and potatoes here of today's presentation, which is transparency regulation for health and welfare plans. And I think, when people think of transparency, maybe they just think of these pictures, right? Pictures like this of very clear windows on a beautiful day with the sky being blue, or a clear window they can see easily through, and there's obviously much more to it, right? Than that. But the goal here, I think, if you have to look at what are the policy goals here, right? Why are these rules in place, right? I think the big three are really just the fact that there's a lot of lack of knowledge, right, by plans and participants about healthcare pricing, right? There's just, knowledge that's important, right? It's necessary to make informed healthcare choices, and ultimately that will lead to a competitive healthcare marketplace. But I think that problem is really kind of, just sort of the nature of healthcare, right? It's just you don't know how much it's going to cost for that Tylenol at the hospital. It's probably a lot more expensive than you think. But there's other problems too that are trying to be addressed. The problem of surprise medical billing, which we'll talk more about that later, balance billing. And of course, the related problem of medical inflation, rising costs. And just this morning, I heard on the radio about more tariffs and more, right? Those tariffs that are coming out, right? They're going to have an impact on prescription drug costs and other costs, and it just increase medical inflation even more. So the goal, of course, is if there's more transparency about healthcare pricing, then you'll kind of know, plans participants are going to know more about what things cost, and that should hopefully level the playing field a little bit. Then I think this last one is really important, and it's really kind of spurring a lot of litigation right now. And so it's something that we're all watching very closely, which is just the fact that these rules, these laws and regulations on transparency try to really aim in and zoom in on indirect, undisclosed, or conflicted compensation, right? Or even unlawful compensation in some cases, by health insurers, medical providers, brokers and consultants, and other plan service providers, right? So that would also include problems associated with conflicts of interest and kickback schemes, between plans and plan fiduciaries and others. So we'll talk a little bit about some of those things and some of the recent litigation that's kind of come about. Okay, so why is it important for you, right? Why does this matter to you all, if, as benefits managers, HR managers, and working with the benefits for your company, for your organization? Well, under ERISA, as amended by the CAA of 2021, plan fiduciaries have to, um, you know, oversee compensation, right? There's other things that they have to do, right? In general, they have to ensure that plan assets are administered prudently and solely in the best interest of plan participants. But one of the big changes here is that they have to make sure that service provider compensation is reasonable, and that they have some kind of process in place for monitoring the performance of plan service providers, including brokers, consultants, PBMs, TPAs, and other plan vendors. And in order to fulfill these duties, they need that information that comes from these transparency rules, information about healthcare costs, like claims data, provider network data, things like that, common healthcare issues of their population, service provider compensation, things like that. That's important to understand because it can help you to fulfill your fiduciary duties. And also one of the big things here is that there's rising litigation, right? There's an increase in litigation pertaining to service provider compensation, particularly as it relates to PBMs. And because of all of those things, that's why this is so important for you all. Okay, so if we're taking sort of a big picture bird's eye view of what the major laws and regulations are that are out there when it comes to transparency, I think these are really kind of the big ones. I mean, there's obviously more than this, right? I mean, even the Form 5500 rules are really a type of transparency regulation, but these are really the big ones and the newer ones that have come out in recent years. And those three big orange circles are the ones we'll be focusing on today's presentation. And then you'll see that other circle there, the hospital price transparency rule, because the same rules that apply, almost exactly the same, to insurers and plans sponsors under the transparency and coverage regulation, apply in many ways to that hospital price transparency rule that came out around the same time. And so we'll be talking about a little bit about the hospital price rules, but we're really going to be focusing more on this orange circle, the transparency and coverage rule, as well as the CAA of 2021. And there's two main kind of pieces of that. The No Surprises Act, which really looks very closely at surprise medical billing and other related rules around that. And then the CAA's, what I call generally the transparency rules, but they're kind of broken down into two different titles. Title one being, prohibiting surprise billing for certain out-of-network emergency services and certain out-of-network services that are provided at in-network facilities. Those no surprises rules went into effect in 2022 and put into place for various patient protection requirements with different enforcement dates, things like new ID card requirements, continuity of care requirements, provider director requirements, things like that. And then there's Title II of the CAA, which is a lot of what we'll be talking about today. It prohibits gag clauses in contracts. It imposes certain mental health parity requirements, requires prescription drug reporting, and requires disclosure, requires that a responsible plan fiduciary at the employer plan sponsor ensure that service provider compensation is responsible and that those service providers are disclosing what they do for what they're paid for and what they do for that money. So the CAA was signed into law on December 27th of 2020. And this transparency and coverage rule, which I'll talk about, was enacted in November of 2020. So this stuff kind of came out closer to the end of the first President Trump term, but it's been evolving, right? Pretty much almost every month since we've seen these things change. The transparency and coverage rule is actually not is a different is actually a regulation that came out under the ACA. It applies to ACA non-grandfathered group health plans. It requires public posting of what are called machine-readable files, or MRFs, that provide certain plan in-network and out-of-network cost amounts. And when it was originally put in, those rules went into effect in July of 2022, and there were also supposed to be some additional prescription drug reporting that was going to come through these MRFs, but that has been indefinitely delayed. But that's a big part of the transparency and coverage rule. Also, it requires plans and insurers to develop an internet self-service tool for participants to compare healthcare costs. Initially, it was for 500 items and services, and then that was expanded to all medical items and services in 2024. So those are really those, the transparency and coverage rule, or TIC rule, and CAA of 2021, which we'll just refer to as the CAA. Those are really kind of like the two big things that have happened in the world of transparency regulation. Um, and we'll be really kind of focusing on those. So what are those key provisions we'll be talking about today in the CAA? Well, we'll talk about the MRFs, which I just told you about, the insurance carriers price estimator tools, the gag clause prohibition, and the annual attestation. We'll talk about this requirement that you disclose upon request to the government agencies a non-quantitative treatment limitation comparative analysis, an NQTL comparative analysis. We'll talk more about that in a little bit. Prescription drug reporting. This is not under the MRF part, but it's a separate requirement, often referred to as RxDC reporting for prescription drug costs. And then we'll talk a little bit about surprise billing and the dispute resolution process, and then we'll talk about service provider fees disclosure, sometimes referred to as the broker and consultant fee disclosure rules, and then also the associated fiduciary obligations that employers and plan sponsors have to comply with. So a lot of stuff we're going to go through, but one of the big ones that we'll be talking about is machine readable files. So let's zoom in a little bit on machine readable files. And what you see here is a picture of a Rube Goldberg device, a very complicated machine. Typically you see these in museums. I know there's one here in Philadelphia at the Franklin Science Center where you see like a little golf ball jump through hoops and land on something, and it jumps to something else. And that's kind of what we're all kind of thinking when we first saw these rules come out in the transparency and coverage regulation. This is a very like convoluted way to get at a public disclosure of healthcare costs, but that's what it is. It's basically it requires non-grandfather group health plans to publicly disclose in this machine readable format, or MRF, these negotiated rates for in-network and out-of-network charges. And the machine readable file or format is not actually readable by humans. So you have to have a separate software just to read that information. So it's a little bit complicated. That's why we always thought of it as kind of a Rube Goldberg device. Now, what's interesting is that the enforcement of the in-network and out-of-network cost MRF disclosure requirement started on July 1st of 2022. But then enforcement was postponed pending regulatory review just to make sure that this requirement didn't conflict with or duplicate the CAA's prescription drug reporting. And then there was deferred enforcement. So on September 27th of 2023, the major agencies here, CMS, DOL, and IRS, they rescinded the deferred enforcement policy on the prescription drug MRF rule and indicated that they would be providing an implementation timeline and future guidance. But then that part of the rule was never implemented. And then more recently, on February 25th of 2025, President Trump issued Executive Order 14221, which called for rapid action to improve and fully implement the health plan and hospital price transparency rules. And then on June 2nd of 2025, so we're just last month, the agencies issued a request for information, or RFI, that was intended to gather public input on how to implement the prescription drug MRF component of those rules, which had been delayed from earlier rulemaking. And really just wanted to get feedback from the public about how these things should be, which data elements should be included in this disclosure, things like that. At the same time, the agencies also issued this FAQs Part 70 that required improvements to the technical data formats to make them more standardized, to better contextualize the data and make it more meaningful. And it's really more for carriers and TPAs to understand. But the goal here is just to make it easier to compare, easier to read that data and compare it to other data of health plans. So what do you really have to do here, right? So, you've got to post this to a public website, right? When this rule initially came out, very few, of the carriers were really doing it. Now, most of the carriers are doing it. So they're posting it to a public website on behalf of the plan sponsor and the plan. But there are still some that don't, in which case, if that's the case, then you just need a link to that data from, which will typically still come from the carrier or the TPA, that you need to post on a public website for your organization. Of course, what most employers do is they have a like a little, compliance hyperlink essentially on their public website that links to this MRF data, and where the machines can read the machine readable files. Um, so this is really, for the most part, it's something that is many employers and plan sponsors out there were very confused by this when this first came out, didn't really fully understand it. The self-insured plan sponsors really need to make sure it's really being handled in their ASO agreements, because it's something that they're ultimately, responsible for doing. But it's definitely just a little complicated and confusing, and a lot of head scratching is involved. But for the most part, it's handled by the carriers, and they're going to get you that data, once you ask for it. So not a huge heavy lift though. Let's also talk about the price estimator tool. That's an interesting development. So beginning in 2024, the carriers really, because the carriers are the ones that did it for all the major health plans, had to provide this website that would be a price estimator tool. So it would allow participants to get personalized out-of-pocket cost information for all covered healthcare items and services, including prescription drugs, through this online self-service, portal, right? A tool essentially. Um, and it also would have to be provided in paper format upon request. And there was a phased-in implementation. So initially it was 500 medical items and services, and then it became all. And you're right. The purpose here is just kind of like what we were talking about before, right? If participants can understand what those costs are before they get the care, right, then they'll be better able to compare, right? Maybe they'll go to a different medical provider where the costs, out-of-pocket costs, are lower. And under the rules, it require the tool to give a good faith estimate of what the medical services and items covered under the plan would cost. Now, what's interesting here is President Trump's more recent February 25th of 2025 executive order mandated that both hospitals and insurers disclose the actual prices and not just the estimates for healthcare services. And this would apply to both the MRF disclosures and the price estimator tool. We've already seen the carriers comply with it. I looked at the United Healthcare website for their price estimator tool. It looks like they are updating it with the actual costs, not just the estimates. But because it's an executive order, and an executive order is really more of a directive, it's not actual law. There are some questions about how would that be really enforced if they just provide the good faith estimate. I mean, right now there is a law saying they have to do the good faith estimate, but there isn't saying that they have to do the actual prices yet. So it's unclear if all of the carriers out there are providing the actual costs. But it is something that the president wants to see, and we'll talk a little bit more about that later when we talk about the Trump effect on transparency. But really, the goal here is to kind of help participants understand the costs. But there were some issues with it, right? Sometimes initially when they first came out, they didn't work very well. They for nationwide plans, the tools were not very accurate because of just regional price variation in different geographic regions across the country. And we just heard a lot of complaints about the fact that they just weren't working very well. And also, there's an issue sometimes where they base the estimates on too many different factors. And so if you are trying to get a cost estimate on a very low utilization medical item, it's possible that it's just not going to give you a good estimate. So those problems, I think, are improving just from everything I've been reading and seeing out there. But it has been a little bit of a lengthy process. So it's not 100% where it probably should be yet, but it's getting there. Okay, let's talk about gag clauses. So, right, this is another big part of the CAA of 2021, so the CAA prohibited group health plans and insurers from directly or indirectly entering contracts that had these gag clauses, which were really contract terms or provisions of contracts that would restrict information, provider costs and quality of care information, um, you know, that type of thing from the plan, right, or another party. And the goal, of course, was because a lot of service providers, carriers, TPAs, they just were saying this stuff is proprietary. We're not going to give it to you. And they were putting gag clauses in the contracts. Since this law went into effect, we have not really seen a lot of these. But what's interesting is that as part of this requirement, you are required to do what's called an attestation, a gag clause compliance attestation every year by December 31st of each year. That where you is essentially attest that your organization's plan does not have any gag clauses. But what they did is they allowed the carriers to do this on your behalf. And so this is often sometimes referred to as the fox watching the hen house problem, right? So the carriers will just tell you, oh, hey, you're fine. You want us to do this attestation on your behalf, we'll do it for you. But there could still be actual gag clauses, right, in the agreements, even with the carrier saying we'll do this attestation on your behalf. And then, of course, it also raises another question, which is, well, do you really even want to know, right? So I think obviously, I think for the most part, it's probably beneficial to know a lot of this data, but it could having that knowledge, right, could put a higher responsibility on your organization to do something about it. So then more recently, I should just mention there was new FAQ guidance issued under the Trump administration January 14th of 2025 that just basically said that this gag clause prohibition also applies to downstream agreements. So if you're a health plan PPA or other service provider that has these separate downstream agreements with other entities to provide or administer a plan's network, for example, then you can't have these restrictions in those downstream agreements as well. So it just kind of extended the scope of that prohibition, and also mentioned that if there's also it applied it to de-identified claims data. So if there's a legal reason for de-identified claims data to go to a business associate that's consistent with applicable laws under HIPAA and privacy rules, and you can't then say that, hey, the providing that data is at the discretion of the TPA or other service provider that's giving access to that data, right? So you can't sort of say, well, it's discretionary as to whether or not we're going to give it to entity versus another entity. And that's another part of this guidance that came out. The other part of that was really helpful here in this new guidance that came out was it explained what to do if there is a gag clause in one of your service provider agreements. There's a step 3 in the attestation form where you expand upon what the prohibited gag clause was. And then another really kind of helpful thing, it's not in the slide, but is they gave actual examples, right? Which is really helpful to understand like what is and what isn't the gag clause. So that was really helpful guidance that came out. And I think one of the big things here is, right, just make sure you're coordinating it, right? I think so. Another kind of big takeaway here is just make sure if your insurer or TPA is doing this on your behalf, just make sure that they're doing it, follow up, get a copy of it, and things like that. But in most cases, it will be kind of handled by the carrier, and that's what most client employers, plan sponsors do. Okay, so let's talk about one of the I think most disliked of the transparency rules, really more of a disclosure rule than a traditional transparency rule. But in the CAA of 2021, there was this rule that amended the Mental Health Parity and Addiction Equity Act, or MAPIA, Mental Health Parity Law. And it required that you create an NQTL comparative analysis, and that this comparative analysis be available to federal and state government agencies who are auditing you, beginning on February 10th of 2021. And I guess let's start off with what is an NQTL, right? So a non-quantitative treatment limitation, or NQTL, is a limitation on a type of benefit that is not something that is quantitative, right? So the quantitative ones are easy, like a cost sharing requirement, an out-of-pocket cost sharing that's required, or it's a numerical amount. You can very easily tell what it is. It's quantitative. But these are things that are non-quantitative because they're more subjective, like fail first policy on getting into a drug rehabilitation program, or medical necessity requirements, things like that. And so what the MAPIA requires is that there be parity between the NQTLs that are placed on the one hand on the mental health benefits versus those NQTLs that are placed on the sort of traditional medical and surgical benefits. And so this comparative analysis that you're supposed to do has to be readily available. Now, it's a practical matter, right? This is not information that most, unless you're in the medical industry, right, like a hospital or something, like most plan sponsors and employers out there just don't really have the tools available to do a real full analysis of the stuff. And so they really have to rely heavily on their insurers and TPAs to get this data. And to make it even worse, right, this law, the CAA of 2021, was signed into law on December 27th of 2020. And you were required to have this available for disclosure to a government agency that requested it by February 10th of 2021. So it was a very short turnaround time. So a lot of employers just they didn't do it, or they just had, just got whatever they could from their carrier or TPA in the beginning. But then during the Biden administration, right? So this law was signed into law under the Trump administration, and then during the Biden administration, there was additional rule that was issued, a final regulation on September 9th of 2024, which added new, very burdensome and additional requirements to the comparative analysis that you're supposed to perform, including a new fiduciary attestation requirement where a fiduciary has to sign off on the fact that they're in compliance with the rules. And there was we're going to talk about a little bit more about this later when we talk about the recent developments section of transparency. But there was a lawsuit by a lobbying organization called ERIC, employer sponsor lobbying organization, that took issue with these new requirements and said they went beyond the scope of what was required under the CAA. And then on May 15th of 2025, quite recently, the agencies issued a statement of non-enforcement that they will not be enforcing the new 2024 final rule that came out on September 9th of last year. And that was much welcome news by many. They actually said they're going to wait till after 18 months after there's a decision in that ERIC litigation case. But it really only applies to the final regulation. So you still have to comply with the statute, the CA of 2021, which still requires that you do the NQTL comparative analysis, but you don't have to go through with all of those additional bells and whistles and jump through as many of those additional hoops as you would have had to if you had to comply with the final regulation. So what are some of the takeaways here? Well, the process of obtaining that NQTL comparative analysis is time consuming and expensive. If you can't get one from your carrier or TPA, then you have to go to a third-party vendor to procure one, and that can be at a pretty high cost. Like I said before, this is data that's not readily available data that you could just pull up quickly from your broker, right? This is very, very specific medical data that they're looking at. And the other kind of problem that kind of compounded these other problems was that carriers were so maybe, I don't know, overwhelmed maybe by all these new rules that came out during the Biden administration that it started adding to the cost of coverage for plan sponsors. Like you had to do so many of mental health treatments, and whether it's whatever the mental health thing was, whether it was ABA treatments or drug rehabilitation, right? It required a lot more on that side than what was there before. So it added really to the cost of coverage. And then, of course, I think is the most common complaint that we're getting now is, well, great, the Trump administration did the statement of non-enforcement, but we still have to do it, right? So even though you don't have to comply with the final rule that came out on September 9th, we still have to do it. And so I think we still hear a lot of those complaints from our clients, from employers, plan sponsors saying, I still got to do it. I don't want to do it, right? And that's, I think, one of the things that is a problem with it. So we'll talk a little bit more about that in more detail later. But that's the kind of the big picture on that mental health parity disclosure of the NQTL comparative analysis. Okay, so let's talk about the ABCs of the CAA's RxDC reporting. That's a lot of acronyms, but basically the basics of prescription drug reporting required under the CAA. And so what happened here was that the CAA required that group health plans and insurers called reporting entities report on an annual basis by June 1st of each year certain prescription drug and healthcare spending information, including certain general plan demographic data from the prior year called the reference year. It has to be put into these data file reports and then uploaded into this portal called the Enterprise Portal on the CMS website. And generally speaking, I would say probably more than 99% of the clients, the employers, plan sponsors I speak to, they can get this really done through their insurers, TPAs, and PBMs, and it's a pretty easy process. The only thing to kind of keep in note is that, it does happen earlier than the June 1 deadline. I think most of the carriers want it to be done by the end of March, some of them end of February. So you got to have to be thinking about this really kind of early on in the year, each year. And I think the problem really only the problems only really come into play if you have a lot of different plans and complicated vendor arrangements. So if you have like a carve out or carved in pharmacy benefit program, and a lot of different vendors, it can get a little bit more complicated to figure out, well, who's handling what. And so my only advice to you, I guess my big takeaway from all of this is if you don't want to be confused, like the picture of this guy in the slide, and you don't want to be, herding cats at the last minute, don't wait until like the Friday before the deadline. That's not going to be a fun Friday for anybody. It's just going to be a lot of herding cats and just difficulties, especially because sometimes it can even take weeks just to get your login ID to get started on that process. So it's just one of those things where give yourself the time you need. Make sure you've got at least, a few weeks before the deadline to do it, and that you're doing it early in the year, in the calendar year. The other thing I should mention here is that the goal of this prescription drug reporting is to produce a research report. So in other words, when all of this reporting is completed, they're going to publish reports, and then that we haven't really seen that yet. But it is expected to be published soon on the CMS website here on the slide. So definitely keep checking that out if you want to get a better sense as to what the prescription drug reporting is going to say. But we don't really have much takeaways from it yet because we don't have all of that data yet in a public place yet. But it will happen at some point soon. Okay, so let's talk about the No Surprises Act, NSA, which is the surprise billing, and we're going to really kind of focus really more on the surprise billing and IDR process for our self-insured clients out there. This is one of those things where when it comes to the surprise billing part, the NSA part of the CAA, most of those things are going to be handled by your carriers, like things like the new ID card requirement, things like that. So for the most part, it's stuff that your carriers will handle. We still occasionally see mistakes here, though, and so it's good to kind of know what the rules are. The general rule here is that, right, beginning for plan years beginning in 2022, the CAA prohibited surprise billing or balance billing of group health plan participants for out-of-network emergency services and for certain non-emergency services that are provided by an out-of-network medical provider at an in-network facility, right? So it's like if you go into even if it's a non-emergency, you go into that in-network facility and you think you're going to pay in-network prices, and then someone comes, let's say an anesthesiologist or something, and they do something on you, and they do their anesthesiology, and then you get this huge surprise medical bill. Well, that is exactly kind of the scenario, right? That's something that in certain cases you can get that removed and be treated as an in-network facility cost, in-network cost. The other big thing here is that there is an annual notice requirement that discusses participant protections against surprise billing, kind of an overview of what the rules are. It has to be made publicly available on the plan's website each year. Now, most organizations don't have a plan website. If you don't have a plan website, it can be also publicly posted on the carrier or TPA's website. It also has to be included in EOBs. If in some cases where in carriers and TPAs do not put it on their website, you could put it on a public website of your organization if you don't have a plan website. And again, that would be kind of like the MRF disclosure link, right? You probably would put that on very small font, in compliance notices on your website. It doesn't have to be a huge, giant hyperlink, but that is one of the things that's required here. Now, one of the things that's really been interesting is that there is a lot of litigation about this dispute process. So the CAA established this Federal Independent Dispute Resolution, or IDR, arbitration process. It's sometimes referred to as the baseball style arbitration, and it's used to resolve out-of-network payment disputes between, on the one hand, the insurers and the plans, and on the other hand, the out-of-network healthcare providers. And after the rules came out, which in the final regulation under the No Surprises Act, there was a rule that said that you have to consider all these different factors. One of those factors was what's called a qualifying payment amount, or QPA, which is the median contracted rate for a healthcare item or service in a particular region, used to determine the participant cost sharing. And that's one of the factors you consider in determining the out-of-network provider payment amount that's at issue in the IDR dispute. So this Texas Medical Association sued. They challenged the regulation because they said, well, it's allowing for the QPA to be sort of the primary factor or consideration, and that shouldn't be. They should, the way that the statute was written, it suggests they all should be given equal weight. And then on August 2nd of 2024, the U.S. Court of Appeals for the Fifth Circuit affirmed a Texas District Court's decision to invalidate that final regulation. And basically, the decision said the agencies exceeded their statutory authority because they allowed these IDR arbitrators to give too much weight to the QPA, and it became, primary, much more important than all of these other factors and considerations. And so they invalidated that part of the rule and said you got to give everything equal weight. And then on January 14th of 2025, the agencies issued FAQ guidance clarifying that you can still use the QPA as a factor, but it can't be the primary factor, consistent with that August ruling. But then most recently, on May 30th of 2025, the Fifth Circuit granted a petition for rehearing en banc, which was filed by those same plaintiffs, the Texas Medical Association, which could end up potentially altering or reaffirming the August 2024 ruling. And just based on what would that mean, right? So that they could either, if they affirm the prior ruling, then it would be the status quo, and you would have to give equal weight to a number of these other different factors, like the complexity of the out of network treatment that was given, and you'd have to give equal weight to all these different factors. If they reverse it, though, right, then the QPA could regain primacy as a primary factor at the discretion of those arbitrators. That, based on all the commentary out there and what everyone's saying, that would actually probably reduce, you know, streamline the administrative hassle of this and reduce costs, actually, if QPA is a primary factor. But if you have to weigh everything, kind of weigh all these factors, give them equal weight, that is likely to kind of increase the costs to plans and issuers. So it's something that we're watching pretty closely. It really, for the most part, really only affects those large, very, very large self-insured plans out there, and insurers much more so than most what most plans have to consider. But so I think, what are the takeaways here? Be aware of that surprise billing notice requirement that has to be publicly posted, and also continue to monitor what's happening in the Fifth Circuit Court of Appeals, because that's where we're probably going to see some changes come down the pike. So I realize there's a lot of content here, but this is probably one of our most important slides because it really kind of changed the rules in a big way, which was that the CAA of 2021 required that brokers, consultants, and other covered service providers that make $1,000 or more of direct or indirect compensation, they have to provide disclosures of how they're paid for what they do. And it also created new requirements for what are called responsible plan fiduciaries. So employers and plan sponsors have to designate a responsible plan fiduciary that ensures that these service providers, that their compensation is reasonable. Okay. And it applies to all plans subject to ERISA. So this was actually an amendment to Section 408(b)(2) of ERISA that had these plans in place already for retirement plans for quite a while. And these requirements went into effect for plan years beginning for contracts entered into or extended or renewed on or after December 27th of 2021. And you have to provide, the brokers and consultants have to provide that in advance. And what's interesting here is just, this kind of created a new requirement, right, for employers and plan sponsors, right? And you have to designate a fiduciary for the purposes of managing the compensation of your service providers. And that was a big change because really it kind of put health and welfare plans at the same place as retirement plans. Many employers and plan sponsors didn't have those fiduciaries and fiduciary committees designated or put into place. So that was a major change. And this is just really more for your own reference as far as what the brokers, consultants, and other service providers have to do, right? They can give you a formula of how they're paid. They don't have to give you the exact amount of their compensation, things like that. And then, of course, there was this temporary guidance that came out at the end of 2021, temporary enforcement guidance from the DOL that said that basically kind of gave a good faith, reasonable interpretation of the law rule so that, you won't be that it basically gives them some discretionary enforcement as to how they're going to impose penalties here, and basically saying if you complied with 408(b)(2) using a good faith, reasonable interpretation of the law, you won't be liable. That was a big development as well. So I think this is really probably one of the biggest pieces of this, right? Because it really ushered in this new world of health and welfare plan transparency regulation. All of a sudden now, um, the plaintiffs bar, saw this as a great opportunity to make money, just like what happened with the retirement plan industry when we saw a lot of the 401k litigation and 401k fiduciary breach claims come out about a decade ago. And they started to file lawsuits in this area. And we'll talk a little bit about that in just a little bit as part of this next section here, which is talking about the big noteworthy things that have changed, the noteworthy recent developments in this area. The first we kind of, for the most part, we've already talked about, which is really that big CAA enforcement change, right? So this is just providing a little bit more detail about kind of what was required and how that statement of non-enforcement was designed to work. It came out more recently. It came out on May 15th of 2025, right? The agencies issued that statement of non-enforcement on the NQTL comparative analysis, which seemed like it was great welcome relief, but you still have to comply with the statutory requirement in the CA to actually still produce that NQTL comparative analysis. So it's a good thing, but I think a lot of employers and clients out there probably would have wanted something a little bit better. Okay, let's talk about the Trump effect on transparency. And I know I've already done a webinar on the Trump effect, and so I'm going to go through this really quickly because just really kind of focusing on what has he done when it comes to transparency. And what's interesting about the Trump administration and why I love this picture so much is that they they're not doing things by in the traditional ways the past agents administrations have done things, right? Here they're taking a picture of themselves eating McDonald's, which I guess you could say it shows how transparent they are. But it's just something you would never expect to see from the head of the Department of Health and Human Services, RFK Jr. over there, and in other administrations. So very different administration from what we've seen before, but they have made it clear, just like the Biden administration made clear, that they see transparency as a major priority for their administration. So, what's interesting here, so here's a timeline of some of the major Trump executive orders on transparency. And this first one is actually from the first Trump term in office, June 24th of 2019, where he issued this executive order on improving price and quality transparency. That actually really, in many ways, became what is the CAA of 2021. So if you look at that June 24th, 2019 EO, right, that was where we saw a lot of the rules that we're still talking about today, and we've talked about in this presentation earlier. And then, more recently, on February 13th, he established the president's Make America Healthy Again Commission. We're going to talk a little bit about that. And then the biggest one, I think, happened was on February 25th, where called Making America Healthy Again by empowering patients with clear, accurate, and actionable healthcare pricing information. And that is the one that is really, in many ways, really trying to build on the June 2019 executive order and kind of make it better than what he did before. So let's talk a little bit about the February 13th one, right? So the February 13th one, while it's broader in scope than its February 25th one, it's really the transparency mandates here are really more about kind of public health. So it's not so much health and welfare plan stuff, but it's really kind of a lot of the initiatives and goals of the RFK Jr. HHS, which is to improve transparency around public reporting of chronic disease and pediatric health data. There's a program in place to review data sharing restrictions that limit access to health outcomes and utilization data. And there are also recommendations to improve transparency in federal health programs. So it is a transparency executive order, but it's not as closely related to what employers and plan sponsors have to do. That is really what came out in the February 25th executive order, which really built upon and expanded his June 2019 executive order, and says right from the very start, right, we want mandatory disclosure of actual prices, not estimates from the hospitals and the insurers. So that's looking at the data that's coming on those price estimator tools from the insurance companies and the MRF disclosure tools, right? We want to see the actual prices, not the estimates, is what they said in the executive order. But remember, an executive order is not law. So there has not been any kind of real major legislation yet or regulation that's really requiring them to do it. And There's probably going to be some time before we see that come into play, but he wants to see the actual prices, not just the estimates. He also wants to see better standardization, better standardized formats, so it's easier to compare prices across different providers and plans. And he wants to include prescription drug prices in the transparency requirements and create stronger enforcement mechanisms for noncompliance. So we already saw initiatives in this area with the recent guidance that came out. We talked about that RFI that came out, request for information, um, and the recent guidance on the MRF and hospital price transparency rules earlier. So that's kind of what he's done, what this administration has done, kind of as a way to follow up on that stuff. And I think the big takeaways here, right, are that the this president, the second term, in his second term, wants to see greater standardization and also simplicity when it comes to healthcare transparency. And I think that's evidenced even in the statement of non-enforcement of the disclosure of your NQTL comparative analysis, because, right, the goal is to, right, if, simplicity means getting rid of a regulation, or not enforcing it, that's what we're going to do. And I think that's pretty cool that maybe not cool, but I think a lot of HR and benefits managers out there probably do think it's cool that less stuff that they have to comply with. It's definitely something a lot of people think is good, even if they absolutely hate the Trump administration. They like the fact that he's trying to simplify things for their plans, do less regulation, and make it easier for the plan participants to shop around, right? Which is the other big part of the policy goals there. Now, I realize we're kind of running a little bit low on time here, so I'm not going to go into all of these litigation developments in a lot of detail. But I think it's important to kind of just be aware that there's three big cases out there where class actions were filed. The biggest one I think that happened, was Lewandowski versus Johnson and Johnson. It was filed in the U.S. District Court of New Jersey back in February 5th of 2024, and really what was so interesting about it was that it not just sued Johnson Johnson, the employer, but also its individual health plan fiduciaries for breach of fiduciary duty for not managing, for lack of oversight of the plan's pharmacy benefits manager, its PBM. And most notably, there was an allegation in the complaint that a drug for multiple sclerosis that would have cost less than $30, if paid out of pocket, cost more than $10,000 through the plan. It alleged that there were issues here, mismanagement of the plan. Now, what happened was in January 2025, the court dismissed the claims for lack of standing, saying the plaintiffs didn't show enough concrete injury because the plaintiff hadn't reached the out-of-pocket max and would have paid the same amount regardless of the breach. But they did find a new plaintiff. So that was considered to be a big victory for employers, plan sponsors. But then they did find a new plaintiff in the Johnson & Johnson retiree medical plan who had not reached the out-of-pocket max and was added into an amended complaint that was filed in March of 2025. But we have yet to see how the court's going to rule on that the employer's motion to dismiss that amended complaint. That's something we're watching very closely. This is just some more information about some of the activity that in the complaint that was at issue. And then the other big two cases are Navarro v. Wells Fargo, filed in the U.S. District Court of Minnesota, which is almost exactly like the same facts as the Johnson & Johnson one, and then Stern v. J.P. Morgan Chase, filed in the Southern District Court of New York on March 13th of 2025. And what's interesting here is that the complaint actually alleges that the Caremark, the plan's PBM, is vertically integrated with its pharmacy, the CVS specialty pharmacy, its mail order pharmacy. And so because CVS is the parent company of both, they see that as a conflict of interest. So that was alleged to be a conflict of interest, and possibly because of JP Morgan's business interests or investments in the sector. So that was, I think, one of the more interesting distinguishing pieces there. But one of the big takeaway here is, right, is that the litigation is increasing, and it's more important than ever to be monitoring your service providers, not just what they're doing, but how they're getting paid for what they do. And because of this litigation, right, it's necessitating more and more compliance efforts. It's more and more important than ever to talk to your advisors, consultants, and make sure that you're doing what's right. Make sure there's no conflicts of interest, prohibited transactions, make sure you're doing the disclosure and reporting correctly, and things like that. And then finally, we have some best practices here. And I think the big takeaway, rather than go through each one of these different little boxes here, is that you know, you have to start somewhere, right? I think even if you just do, let's say, two or three of these things to put a process into place to make sure that you're really thinking about, um, you know, is your plan in compliance with the CAA 2021? Have you designated that responsible plan fiduciary to oversee compensation? Is there a process in place? So let's say maybe even do benchmarking or fiduciary training, things like that to make sure you're headed in the right direction and that you can avoid some of this costly litigation that's happening out there. Okay, so where is it headed? I think one of the big questions I often get and our team gets, right, is like, where are we going with this? Wasn't the Trump administration going to help make all this stuff so much more streamlined or get rid of all the regulation? Um, I think it's probably going to get a little bit easier under the Trump administration for benefits managers and HR managers, but there will be more enforcement. So in other words, even if there's less regulation, which I think is likely to happen, I think that this administration will probably get rid of some of this additional transparency regulation that's too burdensome and too hard to comply with. But they are going to enforce certain rules that they really like, right? Like the hospital price transparency rules, the health plan price transparency rules, things like that. So, and also I think there will be more litigation. I think that's really not really up to the Trump administration, right? The plaintiffs bar sees an opportunity and they have more information than they ever did before because of a lot of this transparency rules, right? So transparency rules is making a lot more of this information public. So the plaintiffs bar can say, hey, look, I know so much more about your plan. You're not doing it right, and I'm going to sue you for it, right? So I think we'll see much more litigation in the years ahead in this area, kind of like what we saw in the early days of the fee disclosure requirements on the retirement plan side. We'll also just, I think, see more plan sponsors setting up fiduciary committees for their health and welfare plans and more closely scrutinizing and benchmarking the fees of their service providers and like what they get for the fees they're paying. And I think that's just kind of looking at it, as sort of a concluding thought about the presidents. I think both President Biden and Trump really supported plan transparency. They both thought of this as a big, important policy objective of both of their administrations. But I think, we'll probably see less regulation, less, more streamlined regulation under the Trump administration than we did with the Biden administration. But when it comes to enforcement, I do think that enforcement is going to still be a top priority for this administration. So that's kind of just trying to bring it all back home here. And as we look through this very long and complicated looking glass of healthcare transparency regulation. So thanks for joining me today. I know that was a lot of material in a very short time, but I really enjoyed speaking with you today about transparency regulation. Thank you.
Thanks, Dan. Thank you everyone for staying on and listening. Dan, thanks for sharing your insights and expertise on transparency and health compliance and everything like that. Once again, for the SHRM and HRCI credits, they will be awarded via email. We'll send you the code. Before exiting, there's a link in the chat to provide feedback, and that will also come in the email to provide some feedback on our survey. Thank you everyone for your time. We appreciate it. And this video will be on YouTube later. Thank you.
Thank you.